morning, everyone. I just came on to give you guys yesterday's live reporting that I did live camera viewing. This is a part where DA Love is arguing her case. So you guys didn't get a chance to see this. I'm gonna put it on lightly on my banner view. Hold on a second. My overlay. Is that light enough, the overlay? Because I normally have it like this. And I think I want you guys to see the some of the pictures. Let's see. Let's do that one. Okay. So I'm gonna go ahead on and play it. Good morning, good morning, good morning, Ruby. Good morning, Sierra. Good morning, Mom's the Boss. Good morning, Miss B. Good morning, Mo Love 67. Good morning, Take Key. Good morning, Terry. Good morning, Carmen. And that's my good morning for everybody. A blanket good morning to everyone. So I'm gonna go ahead and play this, and we will I will be back after this is finished. All right, here we go.
For purposes of the record, the same arguments that I have previously made, I would argue for the exclusion of the 911 call as well. So right now we're dealing with the 911 call and the BW.
Present sense impression 24-8-8031. And looking at McCord versus the state 305 Georgia 18, as well as Grimes versus the state which is at 364 Georgia Appeals, 5/18/2022. The courts considered those particular cases in consideration of the motion. And looking at McCord, which is the most illustrative, that's 305 Georgia at 318. The court's required to first go through a confrontation clause. We'll consider the confrontation clause and how the confrontation clause as relative to Georgia through the 14th Amendment would impose the absolute bar on admitting out-of-court statements and evidence when they are testimonial in nature and when the defendant does not have an opportunity to cross-examine. And of course, those cite are Jackson versus the state, 291 Georgia 22/24, 2012, and Crawford versus Washington 541 U.S. 36, 2004. A statement is testimonial if its primary purpose was to establish evidence that could be used in a future prosecution. So the court has to determine whether or not these statements are testimonial or non-testimonial. The court also illustrates that statements are non-testimonial when made in the course of police interrogation under circumstances objectively indicating that the primary purpose of the interrogation is to enable police assistance to meet an ongoing emergency. Whether the primary purpose of the communication between the police and the declarant is part of an ongoing emergency matter is an objective fact for the court to evaluate. And then the court also defines, as we all know, OCGA 24-8-8032, which is an excited utterance, provides that a statement relating to a startling event or condition made while the declarant was under the stress of the excitement caused by the event or condition may be admitted into evidence under the excited utterance exception to the rule against hearsay. While the declarant must still be under the stress or excitement of the startling event caused, the excited utterance need not be contemporaneous to the startling event. It is the totality of the circumstances, not simply the length of time that has passed between the event and that statement for whether a hearsay statement was an excited utterance. However, in considering whether or not the statements made by Mr. Holloman will first take either on the BTC or in the 911 call, and that would be under 801, 80, I should say 24-8-8031. A present sentence impression is a statement describing or explaining an event or condition made while the declarant was perceiving the event or condition meaning thereof. To be admitted under this exception, the statement must describe or explain an event or condition that is personally witnessed by the declarant and is essentially contemporaneous to the statement. The underlying theory of the present sense impression exception is the substantial contemporaneity of the event and the statement negate the likelihood or deliberate or conscious misrepresentation. And it's got cites Owens versus the state, 329 Georgia Appeals 455 and 458 Penn site. Indeed, the idea of the immediacy lies at the heart of the exception. Thus, the time requirement underlying the exception is strict because it is the factor that ensures trustworthiness. In Grimes, similar to our particular matter, the victim's statement or the declarant statement to the 911 operator was made in this court's assessment while perceiving the event or condition immediately thereafter, in taking a look at the 911 call, it is clear from listening to that particular tape, as well as the two VTC body camera tapes, that Mr. Holloman is upset. He's repeatedly attempting to give his particular version of what happened to him to the 911 operator. And he's trying to get that out of several times to her. He is telling that there's been he's tracking him on the phone, and that he had a weapon put in his face, and he is trying to give the 911 operator the circumstances of what happened and who it is that references that took his vehicle and for what reasons that are stated on that particular recording. The court is of the impression, despite Mr. Matthews Sr. Attempts to the contrary, that these particular statements as recorded on the 911 tape would fall under, like when, for example, Ms. Hallman said, I had a AK-47 chopper put in my face. That certainly would be an excited utterance. The other statements that were made certainly are present sense impressions as they happen immediately or contemporaneously with the event in question, and would be exceptions to the hearsay rule. The court has a concern, as in Bates, while the statements, in this case, the declarant made on the 911 call were made while or after he perceived the event, the later statement to a federal agent at the scene is simply too far removed to be a present sense impression. And there's another case that's cited by the court in Grimes is Manfrey, and that's Mike Alpha November, Foxtrot Romeo Echo, Mr. Steele, at 368 F3rd 382, pinpoint 840, holding that a statement was not a present sense impression when, at the very least, there was an intervening walk or drive between the event and the time of the statement. In this case, we have a little bit of time from 10:50 to 23:04 that, and if I'm looking at the time correctly, we've got about at least 14 minutes later where the first Officer Rebellious, is interviewing the declarant, Mr. Allman, at that point in time.
Your Honor, the court,
I'm sorry, what did you say, Mr. Steele? I'm sorry, Mr.
Matthews.
Mr. Matthews.
The court is ruling. The court is attempting to rule.
I'm sorry.
I don't understand what's happening right now with the government. The court is
okay. First, let me find out. What were you gonna tell me?
Your Honor, the court had previously said that it would find out from Mr. Matthews how long.
It's 14 minutes. He just told me the 911 was made at 10:50 and the officer arrives on scene at 23:04.
And the court told me then that this court would allow the state to respond. So I was waiting on that opportunity, but I have the CAD report. What Mr. Matthews has represented is incorrect, Your Honor.
Yes.
We also have the CAD report. We've emailed it to the court and to parties, and I have a copy for the court here.
So how long are you saying that particular?
There was a 2 to 4 minute max, Your Honor. And I'd also point out, I'm looking at it now. The call was received. It says on the CAD report, I have a copy for the court and a copy for the parties. And the court also said that we were only dealing with the issue of whether or not it was testimonial. So that's why I did not make further arguments. My understanding, and I apologize for not correctly perceiving that, was that the court wanted to argue simply the testimonial part first, because I did not present to the court the remaining parts of the argument, but I do have for the court the CAD report and the distinction between our case and the cases cited by Mr. Matthews. At the court's pleasure, I will present to the court.
I have the CAD report now.
Okay.
And it looks like
in the middle of the first page, Your Honor, it says E911 2250 24, and it says received 2251. Your Honor?
Arrived 22:59.
Correct.
That's 8 minutes later?
No, Your Honor. The call lasted for 5 minutes and 40 seconds.
That's the call itself.
So
call was initiated at 10:50. 24 seconds.
Your Honor, I have.
Received at 22:51:46.
Right.
There was a dispatch at 22:52:47. En route to 22:52:47.
Right.
Arrived 22:59:38. Cleared 23:40. 26:25. So that's how long he was on scene at one time, but he arrives about 9 minutes later.
Your Honor,
9 minutes after the 911 call is complete.
no, Your Honor, it was, the call was received at 22:51:46, and the call lasted 5 minutes and 40 seconds, which would put you at 22:57, approximately 22:57, and then they arrived 2 minutes later at 22:59.
I'm looking at incident times from what you just provided me, Matt. That's what I'm looking at.
Right, Your Honor.
I'm
So,
looking at the time the 911 call was, even if it was received at 22:51,
right.
and you got an arrival time of 22:59,
Right.
that's still about 8 minutes.
What we're saying, Your Honor, is that he was on the phone with 911.
Evening, Mr. Holloman.
My apologies. Yes, Judge. And so he was on the phone, if the court will permit. He was on the phone with 911. The court has the 911 call and can see the time. So he was on the phone with 911 for 5 minutes and 40 seconds. That takes us to 22:57 or 10:57.
That's when he was dispatched. I'm looking at the time on the CAD report.
No, Your Honor, he was dispatched at 22:52:47, Your Honor.
Okay.
And the call, so the call is going on starting at 22:51:46, and then that call lasts, and we can only look at the actual call to see the length of time the call lasts. Mr. Holloman is on the phone with 911 for 5 minutes and 40 seconds. That hang up time is not recorded on the CAD report. We know that because we have the call itself. But what we do have is that 2 minutes after he hangs up, the reason that he hangs up, the court heard the 911 call. He said they tell him they're on their way. So 2 minutes after he hangs up the phone with 911 at 22:59, the officer arrives. And this is only dealing with the testimonial aspect of it, Judge. My apologies if I were supposed to.
I'm gonna rule upon that at this point in time. I think I got enough at this point.
And Your Honor, I would also, will the court, I don't want to fall foul of the court, but will the court allow me to make the arguments, the second part of the argument that we were going to make prior to the court asking Mr. Matthews to address the testimonial aspect?
Okay, well, what I'm trying to look at is whether or not it's how close in time it is. So,
And if the court would allow me, Bates, Your Honor, at section C, I'm sorry if I may. At section C, Bates had argued that the district court abused its discretion by excluding his statement, his as in Bates' statement to ATF agent Kim Underwood, that he had, quote, previously been robbed and did not know there were officers at his door. Bates acknowledges that this statement constitutes hearsay, but contends that the statement is admissible under two exceptions to the hearsay rule. Excited utterance and present sense impression, Your Honor. That under rule.
Okay, Ms. Love, I'm not gonna consider that because A. Bates got arrested too, so that was the other thing. So I'm distinguishing between the fact that our court tells me that the time between the first 911 call and the interview is important. So, because the challenge that I'm having, or the challenge that the court is supposed to resolve, is whether or not there's time to think and walk at this point in time.
And Your Honor, thank you for pointing that out. But the listening to the call itself and looking at it, and then if we're going to examine whether or not it's an excited utterance, exactly what happened in McCord is what happened here. A 911 call is made in McCord. Officers arrive on the scene, and the witness is telling the officer.
Arguing this thing again, Ms. Love. Look, I gave an opportunity to argue it once already.
Judge, you told me
could you let me finish my ruling?
Yes, Your Honor. I'm sorry. I thought that the court's instruction was that we were only dealing.
No, I didn't say that. I did not say that. I thought y'all were finished so I could make a ruling.
No, Your Honor, I don't want to draw the ire of the court, but the court did tell.
Now, come on, really?
Yeah.
Did you really think I was going to split the argument?
Yes,
Adam, no, I didn't. I said I'm going to rule on it. I mean, look, I'm going to rule on whether or not it's admissible under, as you stated, 8032 or 24-8-803. I have reviewed 2 videotape, tapes of this particular incident and a 911 call.
Yes, Your Honor. And well, Your Honor, I did not, I literally, I
Madam,
sincerely apologize to the court.
I'm good at this point in time. So
Judge,
since you have clarified for me, or at least attempted to clarify for me, and I'll include the CAD report as the next court exhibit in order for purposes of completeness of the record. But my concern at this point in time is, and under Bates and Grimes, is whether or not this time period that between the 911 call and the officer arriving on scene is something I have to look at. It's clear I have to.
Your Honor,
In determining whether or not that particular portion is going to be admissible.
Your Honor, the
I'm going
portion,
to admit the 911 call. Whether or not I admit the video is another thing. I'm trying to kind of lay out my reasoning as to this point in time.
yes, Your Honor. And that was, I again sincerely apologize
The court
because
has, the court has.
Okay, well then
the court
sit
has
down
had
then.
Your Honor,
And please sit down.
I would not, Your Honor, I'm going to do as the court asked, but we have not addressed the remaining portions of the arguments that we had regarding the statements that were made on scene. Mr. Holloman saying, I don't remember anything right now. I'm so mad. I'm pissed. I can't even think. This shit got me so mad.
But that's the issue. Therein lies the challenge, is that between that time period, the 911 call, and the officer arriving on scene, Holloman gets a chance to change or think about what he's going to say at that point. It's no longer contemporaneous with the incident. The 911 call is definitely on its own admissible because it has those certain indicias of that will fall under and be an excited utterance or a present sense impression. But
Your Honor, we had Philpott for the court to state, to speak to the very issue that the court is speaking
Madam,
about.
please sit down.
Your Honor, with respect, Your Honor,
I'm going to admit the 911 call. I have issues about the time period between the officer arriving on scene and Mr. Holloman's then tape statement at that point in time. For the reasons that Bates and Grimes mentioned, I'm going to exclude those particular ones at this point in time. But I mean, I think you're going to get everything you're going to get. I mean, everything you're going to get because you asked me to include his statements. And I really do have to look at them if I want to get it right, because of course it's reviewed on abuse of discretion, but I want to make sure that I'm fair to everybody in this particular circumstance.
Your Honor, he does not, in his statements to the 911.
I don't need any help, Mr. Matthews. Okay, stop interrupting me. All of you have that habit.
In the witness's statements to the 911 operator, he does not give the extent of the information that he's giving as he's trying to respond to the emergency with the officer on the scene. He gives the officer on the scene specific information as he's trying to get the person captured. He's telling him, here's his Instagram page.
I have no doubt, and I agree with you. But that's, as Mr. Matthews indicates, the emergency has kind of left at that point in time. I certainly agree about that, and then remember, he's adding to that particular statements that he's making to the officer on scene. He is definitely added to his particular statements there, and the court has some concern as to whether or not they are at that point present sense or excited utterances at that point, and would they be and those particular statements would be testimonial. So, because the officer at that point in time is asking him questions to develop things for a law enforcement purpose. I think the 911 call gets you those statements in. Clearly, his raw statements, perceiving the event, and will fall under either one. I think you're gonna have some statements that will be excited utterance and some statements will be present sense impression. But with respect, madam, I'm gonna rule that two VTC tapes are testimonial in nature, and I'm not going to admit those.
Your Honor, with respect, the court, because I did not comprehend the court's
Madam,
instructions.
you are a seasoned
I am.
chief senior advocate.
Your Honor, I can
Okay, could you please just let it go? That's part of being an advocate. When a court tells you I've ruled, and I've given you great deference and respect, but you keep kind of popping up and say, well, I don't agree with your decision, and I'm not gonna just let it go at this point in time. You've given me everything I need at this point in time, Ms. Love. I'm just making a distinction. I'm ruling some part in your favor and some part not with the state. So, and I've given you a reason why. And I'd ask that you respect my ruling at this point in time.
Your Honor, I definitely respect your ruling. Your Honor, I'd only ask because I feel that the court thinks that I'm not being sincere. I would ask that the court simply.
Now, I'm not saying that you're not insincere, but listen, I'm just telling you at this point in time I've ruled, okay? And I believe that you have made a good argument that is appropriate under the circumstances. It's just that I'm going to rule in part for the state and in part for Mr. Matthews and his concerns in regards to the second statement made at least 8 minutes, 8 to some minutes later than that. So,
Your Honor, I appreciate the court's ruling with respect to, but I did not make all of our arguments at all, Your Honor.
and we're done. Now you're pushing it. Okay.
Yeah. Your Honor, I truly respect the court so much, and I would ask if the court is uncertain about, well, I know that the court truly.
Madam, I'm not uncertain about this. I believe me, you all have given me enough law that I can evaluate this particular circumstance, and I've evaluated it at this point in time, and I feel pretty comfortable with my ruling. If I want to revisit it, I'll do so. But and of course, as you all know, I will. If I don't think that I have gotten something right, I will reconsider my own rulings. I really will. But this one right now,
Yes, Your Honor.
I believe that it's the fairest ruling given the circumstances that have been proffered and presented to me, and in terms of the testimony of Mr. Holloman, that the court has been asked to consider at this point in time on the date in question.
Well, Your Honor,
10/1 of 2020.
I appreciate that, Your Honor. May I just leave, since the court might at some later time look at it again, since I did have these copies printed out for counsel and for the court, may I leave with the court the case law that we had intended to give had I not misunderstood where we were at the moment where I sat down? Would the court permit me to give to the court and counsel these cases in the event at some later time the court revisits it or looks at it again? Or if not that, then if the court would prefer that I send it or do it in some way.
Madam, I'm good. You all don't have to send me every case in the free world for me to rule on an issue. You don't. I'm good. At this point in time, I've considered, and I mean, I got a staff attorney. I certainly can research this as well, just as much as you all can. And some of the cases, you don't need to cite me every single case for me to kind of get a ruling that is sufficient. I mean, I appreciate the length and depth that you all have gone to, you as well as Mr. Steele and others, but I believe that once I've come to a reason, a rationale for my ruling, I think that I'm good at this point in time, okay?
Yes, Your Honor.
Thank you,
I only have 4, so if the court
okay, but I don't want to hear those 4 right now, okay?
Yes,
All right, but thank you very much. All right. I will include the CAB report as the next court exhibit in order. I will also admit, for purposes of this hearing, the 911 call that was made, as well as the 2 VTC or videotaped involvements with Officer Rebellious on the body camera that the court also reviewed. I'll include those as part of the record, in this particular case. All right. Mr. Matthews, you need to prepare a suitable order for my signature, okay? It needs to be done by next Friday. It needs to include I'm gonna include the, you can let the state write their part. Ms. Love, you can certainly do that. And then Mr. Matthews, if you'll put your part in there as well. And then I will ask both sides to get that to me, by the 17th. Is that acceptable, counsel? Ms. Love?
Yes, Your Honor.
Okay, all right.
Do you guys want me to finish this off, or because that's all I wanted to show you guys? I can just let it run into the end. Let me know. Give me a 1 if you want me to continue, let it run, or else I could just stop it and I'll see you guys later. Which one? Okay. I'll let it run. Because some of this you've seen already from yesterday. Okay.
Okay, okay, Ms. Love and Ms. Hilton, ladies, what do we have left to hear? I'm just trying to take a time check at this point in
Sure,
time.
Your Honor. As it relates to that fourth audio that was on the sure. As it relates to the fourth audio that was on the jump drive that the court received,
Yes, ma'am.
is a jail call, which we need to deal with under the residual hearsay exception. And then we believe today we were supposed to handle the other X and 418 motion notice. We were supposed to deal with that today as well, Your Honor. And then last but certainly not least, we have, I believe, ready for the court, the audio that were discussed yesterday.
Okay, have you sent that to Mr. Steele and others?
We gave a copy.
Your Honor, we've given to the defense both the thumb drive that we intend to give a copy of up to the court, which contains the statements of the witness. It's the evidence reviewer, and it's in the evidence reviewer 2, spelled out TWO folder, that the player that the court would use to look at the viewer is in. And we also provided to counsel for the defense the transcript of that particular person's interview, pages 1 through 60 of it. And we began a timestamp of the relevant portions, and we have marked that on the transcript, Your Honor. It is at, I think, 9 minutes and change in. We have marked that in red. We have highlighted various portions of it, and I will give that timestamp to the court. We have as well on that thumb drive presented to the defendants a copy of the interview of witness B and provided them a transcript of that witness's statements as well. And the relevant portions of that witness's statements we've highlighted in the transcript. And so starting on page 30 of the transcript at 9:54:34 is where the relevant portion of the first interview begins. And it goes on through 10:12:55, which is on page 53 of the transcript. If the court prefers and would like to hear any more of it, of course, the entire interview is on the thumb drive and the transcript of the interview. But beyond page 60, the transcript has not been edited for.
Have you otherwise marked it? I know you gave me some time references. Are those marked on the transcript that you have for me?
They are, Your Honor.
Okay, all right. And were those marked on the same transcript you gave to defense counsels?
Yes, Your Honor.
Okay, all right.
And so at
If you
this,
could hand those to Mr. Collins for me, please?
yes, Your Honor.
All right.
And we will, I guess, label them states. States M1 is the first interview, states, or the transcript of it, states M1. States M2 is the transcript of the second interview, and states M3 is the thumb drive containing all of the interviews and the transcripts.
Okay, all right.
And again, it's in Mike.
All right. Yes, Mr. Sheriff.
Just briefly, I understand what's happening in the procedure and what the state is doing. They did give me a copy of the thumb drive. I haven't been able to disseminate it to everyone, but they did give me a copy today of what they're giving you. I would just like to remind the court that of what I said yesterday, that the transcript itself has some errors and
Yeah, you told me that yesterday.
Yeah.
And like I would give an admonition, I'll consider the tape over the or audio over the transcript.
okay, very well. Thank you, Your Honor.
All right. Let me just kind of, just as some housekeeping matters. We are supposed to hear the lyrics motions tomorrow. Is that correct?
Yes, Your Honor.
Given that I have some other things that I'm required to do in my role as the chief, I would like to start our motions at 1 and go to about somewhere between 5 and 6. Do you think that'd be enough time, or do you need more time than that?
That's 4 hours?
Maybe, yeah, almost 4 to 5 hours. Yes, ma'am.
That should be enough, Your Honor.
Just the lyrics motion from the state.
From the state side, 4 hours is enough, yes, Your Honor.
Okay, I will hold that as that, because, yes, I apologize.
Let me, Your Honor, if you give me a moment to find out from Ms.
Yeah, I will not, tell the state, but I've been speaking with Mr. Carl, and he has a PowerPoint I've not seen, and he has numerous articles and cases that he told me he was going to ask the court to consider. He has 3 witnesses that he's planning on calling. So I will, of course, he never told me a time, but if Ms. Hilton thinks it's 4 hours, that's fine. But if the court wants a real time, I would ask him.
Have you taken, is there potential that, and have you seen the materials that he's supposedly gonna show the court tomorrow?
I've not seen the PowerPoint at all. There's 3 experts. He told me one is GBI gang expert, one is City of Atlanta supposed gang expert, Detective Belknap. The third one's also a gang expert, and it might be from another state. No, that may be wrong. It might be Georgia, but I don't remember which county. Okay, Paulding County, Mr. Sharp is saying, and then is, numerous cases. I know you're just asked the state side. I have ours as well, and I know Mr. Weinstein is turning on his microphone.
The only thing I'd like to just clarify, Your Honor, tomorrow is just the state's motion. We will still have the opportunity to respond and argue our motion on Thursday. Would that be the way that would work out?
I believe our motion is a response to their motion.
Actually, someone please check with your colleague. Mr. Carlson told me that he would like to go first because he told me he would like to go last. That's what he told me. He's not letting me argue last. Let
me just see where we are. I can't start till 1 o'clock tomorrow, but my plan is that if it looks like that I'm gonna have to, we may only be able to take some of it tomorrow, and I may have to, given you all are fairly booked up, The only other dates that I potentially have available to finish up would be the 21st, 22nd, and potentially the 23rd. I'd really like to not work on the 23rd as, that's Thanksgiving, the 22nd, I should say, because people need to get ready for Thanksgiving. So that's the only other 2 days that I have any flexibility in my schedule that where I'd finish up whatever I don't kind of get to.
Whatever you say, Your Honor, fine. I just, I don't mean to speak for myself or the state, so please, I know myself will check.
Well, we can check with Mr.
Yeah, we did, Your Honor.
Yeah, go ahead.
And he said probably about 2 hours at max. And that's a conservative estimate. We are not calling witnesses. If the court will allow, we'll be introducing things through proffer. And so that will cut down on a number of, that will cut down on the time. And as it relates to my comment about a response, my comment was, defense filed a motion to exclude. We responded. We will intend to go first, but that was my, what I was saying is that we responded to their motion. So this is a response to their motion, but the state does intend to go first.
Okay.
I don't think it matters, but the zone you actually filed through this. Bring us to the hearing. A motion to admit this evidence.
What you said before.
I'm sorry. I said it, I don't know if it matters to this honorable court, but the state filed through Ms. Rosenwasser and Mr. Geary a motion to admit lyrics. And that was, I can give you the date if you want, but I could give you the date if you would like that as well.
Yes, essentially we have cross motions pending.
So, having said that, Mr. Weinstein, how long do you believe that your portion will take?
If they go first, I believe I will need less than 45 minutes, maybe even 30 minutes to respond.
All right, we'll just see where we are with that. In terms of what I did not get to today, I want to make sure that I do calendar it or it's accounted for. So, Ms. Love and Ms. Hilton, I want to say that I still need to okay, so there's a call between Stanley Mender and Holloman. Is that correct?
Yes, Your Honor.
And how long is that?
Your Honor, I don't believe that should take.
How long is the call here?
The call is about 15 minutes.
All right, I can listen to that. I will listen to that. That's on, and that pertains, is that your, what motion are you trying, or what you're trying to get that admitted?
Yes, Your Honor, that's the basis of our residual hearsay motion.
The residual hearsay.
Yes, Your Honor.
Okay, and then what else? Then I have the Zachary interview
Yes, Your Honor.
that I'm going to listen to. That's about an hour, right?
Give or take, Your Honor. The relevant portions, like we said, my apologies. The relevant portions we highlighted, so not more than an hour, Your Honor, not more than an hour.
Okay, for me to listen to it. And because I need to listen to it before I make a ruling, correct? That's what I indicated to you on that one, right?
Yes, Your Honor. And so the court, I believe where we concluded regarding these arguments, the issue was raised by counsel for the defendants. I think regarding certain aspects of the statements themselves, we proffered to the court what was going to be said, and then we stopped midway where the
and this was the motion to
co-conspirator statements, Your Honor, to admit the co-conspirator statements. So we did not conclude the hearing. We stopped at a point where we just provided to the court the statements themselves, and we'd ask to be allowed to finish up the arguments after the court has had an opportunity to
Okay,
listen to them.
I will listen to these, so I'll be ready to rule on these tomorrow. I'll rule on these tomorrow, so that depending on what time we complete, I will be prepared to finish argument on the residual hearsay motion and the motion for co-conspirator statements.
Will we also be allowed to conclude the argument on the?
And I'm gonna give y'all 15, I'm gonna do like my civil litigants, you got 15 minutes. Up to 15 minutes, you don't need to take it all, but you can certainly do that, because I need to kind of compact this and get these things finished, okay?
Yes, Your Honor.
All right.
And the only other motion that was outstanding that we were to schedule for today, Your Honor, was the other acts 418 intrinsic evidence. And that was separate from what we discussed earlier as it relates to Nichols and Stillwell. We had a separate motion for other acts.
Oh, a separate motion in that respect?
They're all in that notice that the court referenced earlier when the court was looking at the one where they're listed, the 50 something that the court
51 acts,
referenced.
yes.
Yes, Your Honor. They're all, those are the ones.
Okay, all right. All right, we'll complete argument. We need a complete argument on that, Ms. Hilton?
We haven't, we didn't start it.
I know, but
Yeah.
do you need argument on that?
Yes.
You need to rule on it?
Yes, Your Honor.
Okay. All right. Try 15 minutes. Okay, all right. Okay, folks, anything else in terms of ministerial in nature that I need to take up? If not, thank you all as usual. Tomorrow we will start promptly at 1 o'clock, so we can go ahead and I'll take up Mr. Carlson and Mr. Weinstein's matter, and then in the waning hours of the rest of the day, we'll take up the other three things that I need to do. The residual hearsay, and in terms of the call between Stanley, Holloman, Herndon, Minder, I apologize. I'll take up the motion for the conspirator statements and the statement involving Mr. Zachary, and I'll take up the 418, and you all can complete argument on that.
Your Honor, excuse me. If the state is planning on presenting a PowerPoint tomorrow, could we get that in advance, ideally today?
Call why don't you send an email to Mr. Carlson and see if he will give that to you.
Hey,
Thank
Your
you.
Honor, also with the co-conspirator statement, with the co-conspirator statement, Your Honor, there's two interviews. The one with witness one, which will be KC, and then also Quindarius Zachary. So I just want the court to be aware that it's not just it's not just witness two, but it's witness one and witness two.
There's Kenneth Copeland.
Yeah.
Is Quindarius Zachary, and who else?
Your Honor, both the two interviews, the transcripts of the interviews that the court has before the court, if the court would, the names are on the front of each of the transcripts, and we have referred to them in our motion as witness A and witness B. I can write A on the one with KC and B on the one with QZ.
What's QZ's?
Witness B,
Witness
as in
B.
Bravo. Yes, Your Honor. And KC is witness A.
Gotcha. All right, I'm good now. Okay. All right, folks, I'll see you all tomorrow at 1 o'clock, and we'll complete these matters. Okay.
All right, y'all. I am going to stop it. And I want to thank everybody for being here. I'm about to take my butt on to court. But before I leave, I have to put on my little commercial because I got Cash App. All right, here we go. Hold on. Money. guys. That is it for now. I'm off to work. Randa says money, so much money. Thank you to Rosie. Thank you to you. What's her name? What is her name? You song. Wait, hold on. Let me get her name. Hold on. Thank you, Nosy Rosie, and you Stone. I thought it was you Rock. Thank you so much for my gas money. I appreciate you. I got to figure out why my car is kicking. I need to put some gas treatment because it's like, boom. I don't want to blame Ronald, but it seemed like after I gave him my car to use, stuff started happening with my car. I don't want to blame the man, but I don't know, y'all. I don't know. I don't know. You know, when you give people your car, it's like, okay. He probably put some bad gas in my car. I ain't saying that. I don't know, because my car wasn't poop like that before. I don't know. All right, guys. I'm ready to stop laughing. All right, I'll see. I'm not one to say. I don't know. I'm just saying. I don't know. Car started acting really weird. I don't know. My car was fine when I gave it to the dude. Now all of a sudden I'm getting like poop. All right. See you guys later. I will be on to give you guys updates, and yeah, I'll see you guys later. Bye. Thanks everyone for being here. Don't forget to hit the like button, to share, and I gotta get some more folks up in this thing because I need to see you guys sharing and putting in my comment area about it. About you did this. I'm gonna put a little notation. You guys could go into that spot, and I put grease on my forehead. Thank you, Ollie. So yeah, I will see you guys later. Love you guys. Bye. Don't forget, we're going to do that drawing on Saturday. Shout out to Randa. Shout out to Stephanie. Shout out to Kim. Shout out to Gucci, who is sponsoring the turkey giveaway for the 5 family. The 5 family that we're going to bless. We're going to divide the funds that we're getting from them among the family. All right. See you guys later. Love y'all. Bye. Here's the church music.